Hi, I'm Debbie Moraes. Once again, this is Legal Matters, the program that's been designed to address critical, sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. Today, a family topic again, elder care law. Many parents think about their adult children as potential caretakers at some point. Most would not want to think of them as predators. A sad truth at times, but of course that's not the only truth. What do you need to know to prevent confusion or conflict or even a loss? And what do you do if there is a problem? So you may need protection from the kids, but what do you do if you need protection for yourself or from yourself? How do you do that? From driving when you shouldn't, or not canceling a doctor's appointment when you shouldn't, or not taking pills because you want to save money? What needs to be done so that you stay safe? So we've touched on other topics related to elder care and elderly law with estate planning. It's certainly a wide topic. But this time today we will touch on more of the specifics. And once again, we have our legal counsel from the Bazar Grasso law firm in East Providence, Jackie Grasso and David Bazar.
Hi, Debbie.
So let's tackle it. Let's start out with the easy stuff. We had touched on health care directives. That's the basic and the easy. What does that encompass? How do you get it done? How long does it take? What does it cost? Does the doctor do it? A million questions. What happens?
Rhode Island has a statutory form. It's a health care power of attorney. Some people call them health care proxies. As a matter of fact, they're called health care proxies in Massachusetts. You can just go to an attorney. You can actually go online and print it out, a health care power of attorney. It does have to be witnessed. You have to name 2 agents that will be making health care decisions on your behalf. And you cannot name an agent who is an employee of a
medical provider.
In the medical medical profession. So pretty much they're the same. Some lawyers like to draft a living will along with that, and in the living will you would give an advance directive, which simply is telling your loved ones what your wishes are should you become incompetent and you're on life support. The Rhode Island Health Care Power of Attorney has that directive in it, but we also provide a living will along with the power of attorney for Rhode Island.
Do people need to take that with them if they travel from Rhode Island, Mass. To Florida, California, just in case something happens, or is that kept by a lawyer, or how does someone get to know if you're in a hospital elsewhere?
So, as Jackie was saying, as attorneys, when we do an estate plan, that's part of our estate plan documentation. You need to have the will. Everyone usually, when they get to that point and they come to a lawyer for an estate plan, they say, I just need a will. Oh no, it's the will, the power of attorney, the health care power of attorney that you've been talking about, the living will, as Jackie mentioned. The document, when we do them, oftentimes we'll explain to our clients they should take a copy to their primary care physician. They should keep, we do several originals. They should keep a copy in the notebook that we give them. They should perhaps, if they go into a hospital or something of that nature, take one with them, because they'll ask you when you check in, do you have these documents? And if you travel, I mean, you could take them. They can always be faxed or brought down by a family member if something serious happens. It's not something I would think of packing in my suitcase and bringing with me, but it's not a terrible idea.
So these things can change from state to state. Do your children need to know what your wishes are, or should, if you are a child, an adult child of an aging parent, should you be asking your parents, have you taken care of this? Can I help you take care of this? Or do you keep your nose clean?
You should always let your wishes be known to your family members, and you as a child should also ask your parent that. But yeah, I think it's important to do that.
Oftentimes when we're going through these things with an older client who sometimes come in with their children, sometimes without, we'll talk to them about the importance of having an open dialogue with their children as to what all of their plans are, so that there aren't big surprises at the end, and those surprises can in turn cause problems within the family. So just be upfront and let's try to get to the root of why we're doing things and how we're doing them.
So knowing that it's often an uncomfortable kind of topic, do you often have the adult children come to you first for advice on how to deal with their aging parent, or do you usually have the elderly coming to you and saying, I need to sit down and hash this out, flesh this out, and then bring my kids in? How does it usually play out? What are the scenarios?
If somebody wants any type of legal document and it involves an estate plan, it has to come from the individual who is seeking it. Because if someone comes in our office with a relative, we have an obligation to be sure that the person we're representing is actually making a decision to prepare an estate plan. So that could affect a lot of things. You want to make sure that the person's not under duress. What we'll do is we'll ask whomever is with that elderly person, we'll ask them to leave the room, and we have an obligation to speak to the client or clients separately and privately.
We have to do an assessment.
Correct.
That there, as Jackie's saying, no duress or undue influence, that there is capacity to make the decisions they want to make, and that they understand exactly what they're doing and why they're doing it. And once we get to that point and we're comfortable that they know what they're doing and why they're doing it and all of those things have been satisfied, then we'll oftentimes tell them if they want, and sometimes clients come to us and they don't want their children to know everything and why they're doing it, and that's their right. It's their documents, it's their plan, it's their legal rights that they're protecting and working on. So if they don't, we respect that. But if it's something that, through counsel and discussion with them, we feel that maybe it's best to bring in all of the children so everyone knows what the plan is, we'll often do that as well.
Okay. And before we broach the topic about abuses and potential abuses, let's stay with the fact that you may have children who are good, the good kids, kind and fair, and they start to see that their parent is aging or showing signs of dementia and having less capabilities than they should. There is such a thing as guardianship. How does that happen? How does it get enacted, other than the children's guardianship coming from a court, but in an elderly situation? How does that play out?
So as David was saying, if the person is not able to make any decision on his or her behalf, whether it be health care or financial, then someone has to step in. It could be a family member or it could be another close relative. Someone has to step in and file a petition with the court. In Rhode Island, it's with the probate court of the city or town where the individual lives. In Massachusetts, it's with the probate and family court in the county where the individual lives. So you have to petition the court for a guardianship over the person. You also need to provide a medical needs assessment, I believe. So a physician needs to fill out a form that indicates what the person's capacity is if that person has limitations. You have to prove to the court that the individual is in need of help to handle their everyday affairs, whether it be personal, financial, or medical.
So that's not the instrument you use if, say, someone had been in the hospital and is quite capable of full rehab and recovery.
Right. So the guardianship is often a last resort.
Yeah.
So as Jackie was saying, one of the documents is that DMAT, or decision-making assessment tool. That's filled out by a doctor at the point where the client, the person who would be the ward of that estate, is no longer capable of filling out other documents, because one of the things you would check off is that there's no power of attorney in place. And it's really the key reason, one of the main reasons why clients, when they're healthy and capable, should do a power of attorney so they can select the person who's going to make those select decisions for them.
And what happens if they didn't?
Well, if the person cannot make those decisions, then you have to petition the court for a guardianship, and someone has to step in and make the decisions for that individual.
And as someone is planning for their coming and going, if they, as we talked about in previous segments, looks towards irrevocable trusts, Medicaid planning and whatnot, a topic or a question came up that was tied to this, which is, suppose you are an aging person and you want to give or put the deed in your child's name. A question that came up is, if that person who now has their name on that deed, say it's a son, he divorces, is that now a part of the settlement battle, or is that a protected non-marital asset? So
depends on the state.
Right.
You want to talk about Rhode Island
Rhode
statute?
Island, a gift of property by a parent, or any gift really, is separate property from the marital estate. So the quick answer to a long question is the court looks at what is the marital estate, what are the assets that go in the pot that's going to be divided. And if you get a piece of property by gift or inheritance, it doesn't go into the pot, which is different, I understand, from Massachusetts.
And also the key in Rhode Island, as in Massachusetts, it is different, but in Rhode Island, the person receiving the gift or inheritance cannot commingle it with
Right.
their spouse, because when they do commingle it, it's called transmutation. Now it becomes a marital asset. In Massachusetts, Massachusetts does not have that exclusion in the law. So, you do it at your own risk, so to speak, and it can be part of the marital estate.
Good to know, because some
And it will be
seniors do care
considered.
about that.
Yeah.
Let's approach the topic of elder abuse. So, how do you handle it when, first, if it's a senior who's thinking that their children are less than fair and less than kind? What happens if the senior is aware that there's something that's less than proper?
Okay. If they have someone they trust, they can convey it to that person. If there is absolutely no one, they can always report it to the Division of Elderly Affairs. Every state has that, and the Department of Elderly Affairs will step in. They do have volunteers, or even at some time will appoint attorneys to represent that individual. Oddly enough, like 1 in 4 people that report elderly abuse actually report the financial side of it. So it's, statistically, it's not reported as frequently as it should be.
And is there a difference between the personal abuse or the property and asset abuse?
Yeah, because you can have financial abuse, you can actually have neglect. I was telling you earlier, Rhode Island has a law, in Massachusetts, there's a law that says we have, as children, an obligation to support our parents. So letting somebody become a pauper and live in squalor is a violation of the law. And I seem to remember the little old lady who lost her house because of a gas bill, and when they did find that individual, she was living in squalor. There was no reason for that to happen, and there were no family members around. So yeah, there's a law that says you have a duty to support your parents.
Are there certain parameters about that we need to know?
It's general. Well, whether or not it's enforceable, that's a difference.
It'd be a very interesting question.
Correct.
Mrs. Walker, law.
And there is a law that says you have an obligation to report abuse. Now, do they enforce it? I don't know.
It's a little bit different than the child who's abused, where there's a school teacher or medical provider that has that legal obligation to report. But it is a matter of even just moral standards. If you know that there's someone who is an older person who's being abused physically or financially, it should be reported. And as Jackie said, the Department of Elderly Affairs has a hotline and system in place for all of that.
Are there, I assume that if someone is an elderly person, there are certainly websites like Healthcare Institute for Healthcare Advancement, I guess, is one, where they list the kinds of mistakes or problems that elderly people can get into. At the top of the segment I mentioned about driving, there's not necessarily a law unless the person goes to take the driving test again or an eye test and doesn't pass it. But suppose you have an aging parent and you know clearly they are having issues that mean that they shouldn't drive. Maybe it's cataracts, maybe it's dementia. What do you do as a responsible child or friend? How do you handle it?
Well, the state of Rhode Island actually does have in place a process where they can, for medical reasons, take somebody's license. So if you have an aging parent who has either dementia or is starting to get to a point where it's not safe to drive, you start perhaps with the discussion with them. And the discussion over the keys is never an easy one.
No, you're taking their independence away from
and it doesn't work well. If it's a family with some means, you would offer up, I would think, a driver and some other alternative means of getting them around. But that discussion probably doesn't go well. So the next discussion may be with a medical provider. And if the medical provider feels that that person shouldn't be driving anymore and they write a letter that goes to the registry can take the driver's license from them.
I guess with so many things, if families or people in general could talk amicably and discuss things, there probably wouldn't be as many laws or needs for as many lawyers as there are. And to your point, even if someone needs to have hearing aids, glasses, needs other attention, it makes sense the children or the child should surround the parents and say, let's do something. As the child, do you have any legal grounds on which to stand to say, I insist that you go to the doctor because? Or do you call the doctor and say, How does it work?
Well, if you have legal grounds, only if there's a guardianship or if there's a power of attorney in place, yes, you do have legal grounds.
Yeah, but short of that, if someone doesn't have dementia and they want to make their own decisions and they are otherwise mentally capable of doing that, it's really not it's not easy to make somebody do something they don't want to do if you don't have a guardianship over them, or as Jackie says, the power of attorney. And even with that, if they have the mental capacity, they could revoke the power of attorney. So it's more of a discussion than an iron fist.
Good to know. If you have a parent who is in a nursing home, apparently there's a new set of laws that are set up for nursing home abuse. It's a shame that should have to happen, but if you start to see that your parent's care in a particular assisted or nursing facility is less than standard, what is less than standard? How do you know, and what do you do?
Well, certainly if you're walking into a nursing home and your parent is, your parent is filthy in many areas, I don't want to mention them on television, but you know that person's being neglected, and you can complain to the director of the nursing home and go further, complain to the Department of Health, file a formal complaint with them.
And I have been involved in some cases where the standard of care that the nursing home is providing to an individual is falling well below what it should be. And the child made complaints and did follow what Jackie said, and there was some retaliation. And as a result of that, actually, at some point in time, they tried to ban this fellow from seeing his mother. And so a lawsuit followed, and the nursing home was held liable for not letting him see his mother in retaliation, sort of like a whistleblower's kind of act, in retaliation for reporting the abuse and the neglect that was going on at that nursing home. So there is an obligation on the nursing home to provide a certain level of care. And as Jackie said, you start by talking to the director of that home, and then you have to go up the line, you go up the line.
Do you see many of those kinds of incidents these days, or hear?
I hear about them. Every person needs an advocate, especially somebody who's in a nursing home. If you're not there all the time and you stay on top of their care, then your parent might be waiting 7 hours for a sandwich instead of 2, or it could be worse. But someone just told me yesterday that they went to the nursing home and her mother had a stroke, and they called the ambulance, and when they put her on the gurney, they put her on the gurney with a bedpan under her, so she rode all the way from the nursing home to the hospital with a bedpan under her. There's no need for that.
Is that abuse?
I would call it, I would, neglect.
And there's a lot of issues that happen in nursing homes. You have the nursing care that has to be up to standard, the cleanliness and taking care of the individually, their hygiene, their personal hygiene. People in nursing homes, there tend to be a lot of folks that fall a lot, and there's ways of guarding against that with bed rails and other types of devices that can be put in. So it depends on your parent or your elderly person that you're concerned about and their needs. But as Jackie said, you need to be an advocate for your elderly companion, friend, or parent to make sure they are getting what they deserve.
So if someone does sense that there's abuse and they've been monitoring it and they come to you with what they think is a case, maybe they have some documentation, maybe they have soiled linen for whatever reason, something that's proof. What does it cost to deal with this? How long does it take? Where does it show up? In a family court?
We've actually had these cases. We had one not too long ago.
Yeah, I mean, it's not a whole lot different than the medical malpractice cases we've talked about, where the doctor doesn't live up to the standard of care of an ordinary, capable doctor. Well, the nursing home isn't living up to the standard of care. There are experts in that field, and if there are damages as a result of that, sometimes the damages can be severe and extreme. Bed sores that are incurable, and all those other issues that really affect somebody's life. And at the end of the life of somebody, they have just as much right to enjoyment of life as anybody else. You expect them to receive the care that they're entitled to, and if the standard of care is below what it should be and it can't be fixed through conversations and there are damages as a result of that, it's a valid lawsuit.
Is it a lawsuit when either the senior or the child visiting the senior raises two issues, one or the other? How about number one, my parent should not be given Haldol, some sedative that keeps them close to, not catatonic, but so unable to communicate just because it keeps them quiet. Is that considered abuse if they can't prove? How do you prove that someone actually doesn't need that? Is that a tough case, a tough call?
Well, that's a tough call. We're not physicians, but certainly if your parent is in a catatonic state every time you visit that person in the nursing home, I would tend to think that something is wrong.
It's a medical question.
Yeah.
And you have your primary care physician and your own medical advisors and so forth, and you consult with them and say, is this appropriate, is this right?
And in tandem with that, the restraints that are physical, posing and keeping them in a chair. Some may say, well, it certainly keeps them upright, they don't walk around if they have dementia, but you as the child, you don't want to see your parent restrained in any way. Of course, if it's necessary over a period of time, you may know that, but if you debate that, what do you do? Is it first just and only go to that medical or clinical director, and then if they don't do anything and you think that they shouldn't be, do you have a lawsuit?
Well, I think, like as David said, it's a medical question, so I think you should have a primary care physician come in and make that assessment. If you find that it is an abuse, then depending on if there are damages, as David said, it may be a lawsuit.
It may be a complaint up the line, as we talked about, of elderly affairs and all of the other. Department of Health. Everybody that regulates a nursing home that has a stake in making sure the care that's given is correct, you just call everybody that you think is appropriate for that if you don't get the response. And I always say start with the source, start with the home, start with the nurses, the nursing director, the nursing home director, whatever you have to do there first, see if you can resolve it there.
As we've been discussing this, you've mentioned things such as we're not doctors, we would get a doctor. We go through this line. If someone is thinking about having a case or thinking about who they should use as a lawyer, what kinds of questions similar to these, what kind of experts do you use, do you need them, what kinds of interview questions would you reasonably expect to be asked if someone comes in before they think of retaining you or some other lawyer for an abuse case?
We would want a set of facts, we want dates, we want times, names, obviously, addresses, any witnesses, names of doctors that have been in to see the person, names of primary care physician. It's fact-driven. It's fact-driven.
That's what you would ask. What should the prospective client be asking you on the other side? That's, I guess, if the lawyer doesn't ask you for that, that would probably be a tip-off that they're not really prepared to handle such a case. But
it's like you would do with any other lawyer on any other case. You might want to know what their experience is and whether they've handled these types of cases before, what kind of experts do they have access to if it's a situation that requires an expert witness. And again, it's usually for me, what I tell clients is you need to have a rapport with the attorney that you're going to see and make sure you're comfortable with, number one, how they're going to handle the case. So how you're going to handle the case might be an appropriate question. A lot of times clients ask me, are you accessible? Can I get to you? Can I speak to you? Or do I have to talk to a paralegal or somebody else? So it's whatever gives you the comfort level with the attorney that you're seeking advice from and hoping that will handle your case.
And more importantly, you want to ask the attorney what the fee arrangement is as well.
And the fee arrangement.
Are most of these abuse cases, are they fee-based or are they only if you settle?
You're talking about contingency fee-based. And that's what they usually would be.
It's contingency. Is it a fair question for someone to say, here's the case, and I guess you do free consultations. What are the chances that this is a legitimate case, and what are the chances of winning? Is that a fair question to ask?
It's a fair question, but I will always tell my clients, I don't have a crystal ball. I can't tell you what's going to happen in the future. Do I think there's a likelihood that we may prevail? Yes, but I can't predict the future.
And we wouldn't take a case that we don't think we could win because if it's on a contingency, we don't want to waste your time or our time. So the first step is, as Jackie said, find out all those facts. Then we can give you a not a prediction of what would happen, but we can tell you, we're not going to take this case if we don't think there's at least a good chance that we could prevail on this case.
Good to know. I understand that lawyers in some states can demonstrate that they have some proficiency or specialty, legitimately, in elder care law. I guess they call it a certification. I'm not so familiar with that here. Does that exist in Rhode Island, Mass? Does it exist anywhere that we should be aware of?
In Rhode Island, you can't be certified anything.
In anything?
Right.
Yeah, you're not allowed to advertise that. You can advertise what you do, but you can't advertise that you are certified.
Massachusetts also, Jackie?
Yeah.
Okay.
Rhode Island doesn't have a process to certify lawyers as experts in any area. We don't break it down like doctors do. I'm an orthopedic surgeon or I'm a neurologist or that type of thing. So Rhode Island says, are you competent to practice law? If so, we'll give you a license to practice law, i.e. you can pass the bar exam and you have the ethical background to do practice law, but they don't go to the extent of saying, we're going to give you a special test to decide that you're a personal injury lawyer or you're an elder care lawyer or anything of that nature.
There are some special tests, though, if you want to be a patent lawyer.
Yeah, but not by
specialize in
the state
patent.
of Rhode Island.
Yeah, that's correct. It's a separate bar exam.
Not surprisingly, with the number of seniors who are active and involved in questioning things, there's a National Elder Law Foundation, NELF, that people can Google, and they, depending on what state they live in, depending on where they're seeing this, even through YouTube, they might have an occasion to say, maybe there is such a certification, but just not Rhode Island or Mass. Other issues that are that usually that might confront you as lawyers when it comes to seniors and elder care. What are the common
Sometimes
questions?
what I'll see repeat questions about are financial abuses. It's sad to say that you would give somebody a power of attorney, you entrust that person with all of your assets, and that person can squander the assets. Now, in that case, you want to report it to the Department of Elderly Abuse, and in some cases, the state police even becomes involved because now it becomes criminal. So I do get questions about that, and questions by elderly who are concerned about that. You know, what happens with my money if I let somebody be a power of attorney? We have to advise them that there's a possibility that this person has equal access to all of your finances just as you do.
Did you say the Department of Elderly Affairs or Department of Elderly Abuse? Is there a difference?
Same.
Jackie?
It's Department of Elderly Affairs.
And
Jackie's,
abuse
I agree with Jackie 100%. The biggest concern you see sometimes is this abuse of an elderly person's finances. The other side of that coin sometimes is when the person has really sort of gone over the edge and lost their mental capacity, Alzheimer's, dementia, whatever, and they start asking the same questions over and over about money that's long been spent on something. You have to be able to follow along where it's real or imaginary sometimes.
And that's what lawyers have to do at times?
Well, sometimes, but really it becomes a problem. If it's reported to the Department of Elderly Affairs, they have to sort of ferret that out a bit.
Is it smart for the senior's nearby friend to stay on top of or close to that senior just to make sure that the kids aren't doing or that the power of attorney isn't? I don't know how close they can be or how much their business they would necessarily know.
Well, I would be concerned if someone comes in with a next-door neighbor who wants...
Yeah.
Yes, that's a red flag for
Right.
you.
Yes.
And more concern would be if you have multiple children, they're usually a good check and balance on each other.
Correct.
So whether you're hoping to understand your personal finances or elderly issues in more detail, we hope that this has been helpful to you. If you have a question about this or any other topic, we always invite you to email Legal Matters, legalmatters@fullchanneltv.net. Our discussion of legal matters will continue. We hope you'll stay with us.